Good afternoon, everyone. My name is Madhusudan, and I welcome you all to this N100 series of polity classes. In this series, we are covering all the themes of polity from mains perspective. We discuss the details of all the theme, and we have been choosing those themes only which have a probability of being asked in 2025 exam. Okay, so I welcome you all. Just confirm before moving further that if audio, video, everything is clear. Good afternoon, Yogesh. Is audio, video, everything clear? Just confirm. And see, today's topic is separation of power. Separation of power, as such, this is something which is mentioned in the main syllabus. But as such, when we study polity from like in the foundation course or somewhere else, we usually study judiciary separately, we study legislature separately, we study executive separately. We do not study as such separation of power. But what I have taken, because we are going from the mains perspective, I have taken separation of power as a topic, and separation of power will definitely go hand in hand with checks and balances, and then all those topics where separation of power is followed or violated, we are going to cover here. And the rest of the items which would be left would be covered in the topic of, say, executive or judiciary. We have already covered legislature. Good afternoon, Manoj. So let's see. Uh, can you tell me what is this separation of power? Can you please answer what is meant by separation of power? Separation of power is as such very simple concept. There are three organs of the state: legislature, executive, judiciary. And there are three prominent functions of the state. That is law making, then implementing these laws, and obviously if there is any dispute between any two actors in the state, then adjudication of those disputes. So the idea of separation of power says that these three functions should be done by three different authorities or bodies in a state. It should not be that there is only one authority, only one person, only one head of the state who is involved in all these three functions. Okay, so this, yeah, different duties to different organs of the government. Yes, you are right. So if we have to write the proper definition of separation of power, it would go something like that. It's an organization structure where responsibilities, authorities, and powers are divided between groups rather than being centrally held. And in terms of polity, this is a general definition of separation of power. And in terms of polity, these three groups, we know that these are legislative, executive, and judiciary. These are the three different functions, and they will do their own. And this is the concept of separation of power was given by a person named Montesquieu. Montesquieu was the philosopher who has given this concept of separation of power. There is slight mistake here in the spelling. His actual spelling was Quieu. Okay, he was a French philosopher. He gave, and why was he saying that there is a need of separation of power? Because he saw that during monarchy there was something called concentration of power, and in concentration of power, all the powers are concentrated in the hands of the king. You must have seen the movie Jodha Akbar, or any other movie where kings are shown. Or I am taking example of Jodha Akbar because it's a realistic movie. So in Jodha Akbar, Akbar used to make the rules, laws. He even propagated a religion. And then in case, obviously, he has a army, he has the bureaucracy who used to implement those rules. And in the end, you must have also seen that if there is any dispute, if there is any complaint, people used to come with the complaint in the court of the king, and he used to do justice also. So all the three functions were concentrated in one person, that was king. And obviously Akbar was a good king, supposedly. I mean, you may agree or disagree, but more or less we have this opinion that Akbar was a good king, but not all the kings have been good. Like Aurangzeb, he is not being considered as a very benevolent king. So there is a high risk that in case there is a concentration of power, there is going to be something called despotism. There is a possibility of dictatorship. Why there would be possibility of dictatorship? Because no one is going to stop him. Suppose he make a bad law, there is no control over him. Suppose he does not act as per the wishes of his law. Like he can make a law that everyone would be given 100 rupees tomorrow. He does not have 100 rupees in his treasury. So rather than borrowing money from the market, what he can say that I will not give 100 rupees. Okay, so there is no restriction on his power. There is all chances of dictatorship. This is something that we witness in current day North Korea. In North Korea, you know what happened? In Hindi, despotism is called Tanasahi. Okay, so despotism, dictatorship, they are one and the similar terms. Okay, they all mean the same thing, that there is someone who is, there is no control over him. He has all the powers and there is no control on his authorities. That is despotism. Okay. In North Korea, what happens that a flood came, and because of the flood, few people lost their lives. There was loss to property as well. So all the engineers, etc., who were supposedly involved in construction of dam or maintenance of the embankments, etc., it was identified that there were around 43 engineers who were guilty of dereliction of duty. They did not do their duty properly, and they were hanged. Death sentence was given to those engineers who were found guilty. And I mean, I don't know if what was the process followed, whether they were given the opportunity to present their case or not, but a flood came, few people died. Later on, engineers were hanged. The king decided that this is how it is going to be. There was no authority to restrict the king. This is something that can happen in dictatorship or despotism. Now, Montesquieu said that this is something that is not good for democracy. In democracy, there is need of limited government, there is need of constitutionalism, and for constitutionalism, there should be separation of power, not concentration of power. Okay, so what he said, that to prevent the abuse of power by a single person or a group of individual, like it may also happen that the council of minister is together taking an action, the same council of minister is uh, part of legislature, executive, judiciary, then also there is going to be abuse of power, and then it will guard the society against the arbitrary, irrational and tyrannical power. These are the words that must be there: arbitrary, irrational, tyrannical powers of the state. Okay, and it will safeguard the freedom of the individuals. Okay, how? Because see, like the way we have in India, legislature is making a law, and legislature has the representation from the people. So people themselves are making the law. Executive has to implement the same laws, and then executive, if like legislature can control the executive if it is not following those laws, and then executive, if in case executive does not follow those laws, we have judiciary who will handle the disputes, who will say that okay, you are not following the due process or the law. So this way, the freedom of the individuals would be protected. Otherwise, through unlimited power, this is something that we have seen in earlier as well, that there is always a fear that when we have surrendered some of our rights to the state or the government can become too powerful and it can curb all our rights. So to prevent a state from becoming so powerful, Montesquieu gave this idea that there should be separation of power. Okay. Next is, a question can be asked that where in our Indian constitution do we find separation of power? Can you tell me? Where do we find? Before that, I mean, you give my answer to me, where in our constitution we find separation of power. I will tell you one more thing, that Montesquieu also said that when we will find that there is separation of power. So Montesquieu said that there has to be three different criteria has to be fulfilled for separation of power to be achieved. Okay, first is about function, that one organization should be doing one function. An organization or one, or if not organization, it would be in the organ. So one organ, one function. One organ should not be involved in the function of another organ. That is the first criteria. Second says that exclusivity of individuals. What does it mean? He says that a person, an individual, should be a member of either of the three organs. The same person should not be a member of two organs at the same place. Same time, sorry, not same place. It cannot be that someone is judge also and someone is legislature also and someone is in the part of executive also. So they should have their different personnel. Okay. And the third point is that one organ should not interfere I hope it is readable in another's interfere with another organ. So first thing, there would be three organs to do three different functions. Second is they will have their different person, and then one will not interfere with the functioning of another organ. If these three criteria are met, then we would say that there is separation of power. Now the question comes is that whether Indian constitution has separation of power or not. See, as such, I would give you the answer that Supreme Court has said that separation of power is part of basic structure of Indian constitution. Supreme Court has given this judgment. This is something which was said in Indira Gandhi versus Raj Narayan case. In that case, Indira Nehru Gandhi versus Raj Narayan case. In that case, Supreme Court has said that separation of power is part of basic structure. Since it is said, we have to justify how separation of power is there in Indian constitution. So let's see, go by each function. Do we have separate function for three different organs? Yes, we do have. In case if you open the constitution, in part 5 of constitution we have union, and in that chapter 1 is about executive, chapter 2 is about legislature, chapter 4 is about judiciary. So our constitution establishes three different organs of executive, legislature and judiciary to do these three different functions. So from that it is clear that there is separation of power, there is three different bodies which exist. Okay. Next is there is exclusivity of individuals. Here also you can say that yes, there is bureaucracy which does the executive function. There are lawmakers which does the legislative function, and then there are judges who does or who do the judicial function. So we have exclusive individuals for these three different functions. Then we have one organ should not interfere with another organ. So broadly speaking, this is also valid that these organs do their own functions. In fact, there are certain provisions in our constitution also that make sure that one organ does not interfere with the functioning of another organ. For example, Article 50 of our constitution, this is a DPSP, that says that efforts should be made to separate judiciary from executive. Okay, so this is again, this is saying that efforts should be made to bring about separation of power. Next is Article 121 and Article 211. It says that the conduct of judges, you may write it down as well. In this article, it says that the conduct of judges shall not be discussed in the parliament or state legislature. This is about parliament and this is about a state legislature. So the conduct of judges shall not be discussed in the parliament. So this is again saying that parliament can discuss anything, it has to make the laws, but it cannot discuss, it cannot interfere in the functioning of judiciary. Okay, in fact, the autonomy or independence of judiciary has also been declared as part of basic structure of Indian Constitution. Independence of judiciary has been declared a part of basic structure of Constitution. This was done in the Keswarananda Bharati case itself. Next is Article 122. This is something that we studied yesterday also. Do you remember what was there? Article 122. Please tell, yesterday class only we have seen it. This says that courts should not inquire, court not to inquire into proceedings of parliament. We have seen yesterday that no action of parliament would be questioned in a court of law for any uh, for not following the proceeding, etc. So this article, article 122 is about the parliament and 212 is about a state legislature. These articles says that the court should not inquire into the proceedings of parliament. Okay, and then article 361. This article says that there is immunity to president and governor. So for any action taken by them, they shall not be held responsible in a court of law. In fact, no criminal proceeding can be initiated, continued against parliament or governor when they are in office. So they have been given immunity. This is also a symptom of separation of power, so that judiciary does not interfere in the function of executive. This is like where judiciary does not interfere in the function of legislature. This is where legislature does not function in the interfere in the functioning of judiciary. So there are various provisions through which it has been made sure that there is separation of power in between three organs of the state. Is it clear? If you have any doubt, please ask. There has been a question has been asked directly, so you must have clarity. You must memorize those article numbers also. Until unless you write your answer with this article number, you will not get very good numbers. Next is that apart from separation of power, there is also a necessity of checks and balances. Suppose it so happens that parliament is doing its own function, judiciary is doing its own function, and legislature is doing its own function, and they become arbitrary in their own domain. Suppose they are making law and parliament start making arbitrary law, unreasonable laws, or even like judiciary become corrupt. It starts giving judgment which are illogical, unconstitutional. In that case also there should be some mechanism of checks and balances as well. So Indian constitution also provides a part, I mean along with separation of power, it does provide mechanism for checks and balances. What are those mechanisms? So first let's see how legislature ensure or rather how legislature checks the executive. So like we have a provision that executive shall be collectively responsible to the Lok Sabha, collective responsibility of council of minister, or we have mechanism like question hour, confidence motion, no confidence motion, adjournment motion. So various mechanisms there are. We have seen in the last class that how legislature ensures accountability over executive. Okay. Then legislature also ensures accountability over judiciary, like the removal of judges. Removal of judges is done by legislature only. So through this process, legislature also keeps a check on judiciary. Then executive also keeps a check on legislature. How? Veto power of president. Whatever be the act or bill passed by the parliament will become act only after it receives assent of the president. And president is, although we have seen that president is part of parliament also, but for this chapter we will be considering, since president is head of executive. Okay. Then executive appoints judiciary. It is the judges are appointed by president. So we will see that executive also keeps a check on judiciary. I know you must be itching to say, sir, judges are now appointed by judges only. There is a collegium system. Yes, but theoretically, for the time being, when we are writing that how we have checks and balances, we shall write that president appoints the judges of the High Court and Supreme Court. Later on, we shall see that how these are not being followed properly as well. Next is how judiciary keeps a check on executive and legislature. So for both of them, judiciary has the mechanism of judicial review. We shall study about judicial review, PIL, and the issues that are arising out of PIL in detail. But for the time being, we have judicial review. You just simply understand that judiciary can review any unconstitutional action of executive as well as legislature, and any act of executive and legislature can be declared null and void if it violates constitution. So we are saying that all these organs, three organs of the state, there are mechanism through which they have a check on other organs of the state as well. So they are independent, at the same time they are keeping a check on each other as well, so that there is no tyranny, there is no despotism that develops. So along with separation of power, checks and balances are also necessary to ensure that people enjoy freedom, to ensure that people enjoys democracy. Okay. Next argument that comes is that in a parliamentary form of government, we have parliamentary form of government. In a parliamentary system, what is parliamentary system? So parliamentary system is not that where you have parliament. That's not correct. Parliamentary system means where executive is responsible to parliament, where council of minister have to enjoy majority in the house of people to ensure their continuance. As soon as you will lose majority in the house, you will have to resign. The government will collapse. So this is called parliamentary form of government, where executive is responsible to the parliament. Where executive is responsible to parliament means where the council of minister has to enjoy majority in the parliament. In our case, it is only in the Lok Sabha. Okay. So in a parliamentary system or parliamentary democracy, there is no strict separation of power. This is a line that you must write, that this system itself that India has adopted, it does not prescribe for a strict separation of power. How? Because see, who can be a minister in our country? Ministers are part of executive. Executive includes ministers, and to be a minister, you need to be a MP. You need to be a member of parliament, then only you can be a minister. So invariably there is overlap between, and this MP is part of legislature. He is member of parliament, he is part of legislature. So there is overlap between executive and legislature. And we have seen it. One of the principles which were given by Montesquieu is that the personnel or the people manning these three organs of the state, they should not overlap. The same person should not be a member of two different organs of the state. Here we see that there is an overlap between executive and legislature. So as such, in a parliamentary system, it is never possible to have a strict separation of power, or it is also called as watertight separation of power. In USA, here again we are deviating slightly from the USA system. USA system has a strict separation of power. In USA, president is elected separately. There is a separate election for president and there is a separate election for Congress. And once a person is elected as a president, he need not enjoy majority in the house. There are times when say the president is from Republican party and then Democrat has the majority in the parliament, in the Congress. And at times it happens that president wants to execute a particular program. For example, Donald Trump wanted to make a wall between US and Mexico, and the Congress was not sanctioning budget for the same. So there is often a stalemate. There you might get the news that the US government will come to a standstill. Budget is not being passed because there is a there are various instances where president and the Congress are not on the same page. Okay. India has intentionally decided not to go for the presidential system. As we have seen that here, in case of money bill, complete power has been given to Lok Sabha, and the government always enjoys majority in the Lok Sabha. So in India, there cannot be any such situation where executive want to do something and legislature is not sanctioning budget for the same. Okay, is it clear? If you have any doubt, you may ask. Okay. So now we shall move to the second part, that is what are the issues with separation of power, or rather what I have chosen is what are the areas where separation of power is not followed, where we are violating separation of power. I mean, apart from the things that I have just discussed, that the parliamentary form of government by essence itself, by principle itself, cannot follow the separation of power. But apart from that, we have certain things like we have the mechanism of ordinance. Ordinance is a violation of separation of power. Ordinance is a law made by president. We shall go into the detail of ordinance. I am just listing out the items where we are violating the separation of power. Then there is delegated legislation. Delegated legislation is when uh, Parliament delegates its function of law making to some other authority, which is obviously part of executive. So when executive is making a law, these are both the laws made by executive. There is difference between ordinance and delegated legislation, I will tell you. And then judicial activism, where judiciary is entering into the domain of executive or judiciary, or even the parliamentary privileges. Yesterday we have already seen that this violates separation of power. Okay, so these are the instances which are perfectly legal, which are being followed, which are constitutional, yet they are in principle violative of separation of power. Now we shall see them one with one, but before that let's also see the issues with checks and balances. Okay, how checks and balances are being less effective nowadays. Okay, so the first instance is that there is reducing ability of parliament to hold executive accountability. Yesterday we have seen how parliament is weakening. So all those factors that we have seen yesterday, how this can be a question in itself, how parliament's ability to hold the executive is reducing. And apart from the points that I have told you yesterday, add one more point, that is the single party majority government. This is also reducing the parliament's accountability mechanism. See it in combination with anti-defection law, that whatever decision will be taken in the parliament, it would be taken by majority. And when there is a single party majority and there is anti-defection law, no MPs, the government would never be questioned by the parliament. So that's another reason how executive is becoming less accountable to parliament. There was also a question that was asked in the last class, that whether the 40 days exemptions from arrest that has been given to the MPs before the start of the session, during the session, and then after the uh, parliamentary session, is it for both civil and criminal cases? The answer is it is only for civil cases. It is not there for criminal cases. Okay, from criminal cases the immunity is with the president and governor, and that is complete immunity. Okay, that we have seen today, article 361, and that is uh, what I am referring to is article 105. And article 105 that talks about the privileges of the parliamentarian, it does not mention explicitly this provision of 40 days. Okay, this provision of 40 days has come from convention, from the British convention. So we have seen that there are some privileges which are documented in constitution, some in the rules of the Lok Sabha, and there are some which are coming through convention. So this is one of the privilege that is coming from the convention followed in British Parliament. Okay, now let's come back to the topic at hand that we were discussing. So this point you can answer from yesterday's class. Next is collegium system. Again, the checks and balances required that the executive should have a role in appointment of judiciary, through which executive will have a check on judiciary. Now that appointment is done by the collegium system, collegium is part of judiciary only. So effectively the checks and balances are reduced. Next is no judicial accountability act. In case judges indulge in some misconduct, They can have, they can act in a biased manner sometimes. They can give the wrong judgment intentionally. They do not follow the procedure. A lot many things can happen. They become incompetent. There is no judicial accountability. Suppose a bureaucrat acts in a say wrong manner. Immediately he is suspended. Immediately he is transferred. Sometimes disciplinary proceeding is started. Some penalties imposed, sometimes they are demoted as well. All those actions can be taken, but in case judges make any error, there is no such provision. What happened? Yeah, so in case judges make any such error, in that case there is no provision for any action. The only thing that can be taken done against judges is removal, and removal can happen only in case of there is gross negligence, there is gross misconduct. In case there is a small deviation, a small, there should be some mechanism of a small penalty as well. For example, when you are absent from your duty uh, in bureaucracy, a letter is often issued, so cause notice is given. You are reprimanded when you are absent, but for judges, nothing is known. What action is taken, how is taken. There are time and again where like judgment is delayed for years and years. Then Supreme Court just then the only mechanism available is in case it is High Court, you will go to the Supreme Court and then you will complain to the Supreme Court that the High Court is not giving its judgment. Then after 1 year, Supreme Court take up your matter and then it will ask High Court to issue the judgment. And in case Supreme Court is not doing due diligence, you are on your own. Then there is the issue of delayed justice, and in case justice is delayed, then also, because see, through judicial mechanism, through mechanism of judicial review, the checks and balances were ensured on executive. And if the justice is delayed, it means that executive can do its own thing. Suppose you are arrested and you are kept in jail for 4 or 5 years, and after that your case come to the court and court says that no, the executive is overstepping its boundary. Judicial review action is taken, you are ordered to be set free, but by that time your freedom has already been curbed. So the checks and balances are not being implemented properly if there is a delayed justice. Then this is, there can be a separate question on delayed justice, judicial restraint, all those things. In that case, what you have to, then these arguments you have to remember. There I will ask you again that what is the problem with delayed justice. You must remember these arguments. Then judicial restraint is a scenario where judiciary limits the scope of its power. This is opposite to judicial activism. In judicial activism, judiciary gives broader interpretation to the fundamental rights. In judicial restraint, it is said the judiciary should limit its functions to its core function, that is adjudication of dispute. It should not give broader interpretation. This is again limiting the power of judicial review. This is also keeping the checks ineffective. Next is political influence on various institutions. So there are various institutions like say Election Commission of India, CAG. These institutions are also given the mandate to keep a check on executive. And when these institutions are also getting influenced politically, the appointment are politically being made, they are also not effectively keeping a check on executive. Okay, so these are the various examples. You have to, when you write an answer, if a question comes, you have to explain all these terms. Would you be able to explain these terms? Or if you need any explanation, you may ask. Reply, please reply. So now we shall move to next item of our agenda. One after another we shall take various issues, like see the collegium system and the issues related to judiciary we shall take in the tomorrow's class. Tomorrow class would be dedicated to judiciary, whereas the issues which are like issues like ordinance, veto power, which are related to separation of power, we are going to take in today's class. Okay, so let's start with the first issue, that is of veto power of president. Again, this is veto power of president is simply like if an act, if a bill is passed by both houses of the parliament, then it is presented to the president. Then president has various options. He can give assent to the bill. He can say that he rejects assent. For that, the word withhold assent has been used in our constitution. This is something a kind of revision. We have already discussed it. Okay. Then he can send it for reconsideration of the parliament, and then he may also decide not to do anything. In this case, the bill will become an act. In case reject assent, this is called absolute veto. In case he send it for reconsideration, this is called suspensive veto. In case it is sent for reconsideration, the House or the Parliament may accept the recommendation given by the President and pass it again. Sometimes it may happen that the House does not accept the recommendation of the President and pass it again in the same format. In that case, in case the Parliament passes it again, it is mandatory for President to give his assent. So here is the case. It's simple. Parliament passed the law again once. It went to the president. President said that there is some issues. Please bring about these changes. In case the parliament accepts those recommendations, well and good. It would again be given to the president. President can give his assent. In case the parliament does not accept those recommendations, in that case, what will happen that it would again be presented to the president, and second time it would be mandatory for the president. So the president can send a bill back for its reconsideration only once, and in the second time also the parliament have to pass the bill with simple majority only. This is different from the concept which is followed in USA. In USA they have something called qualified veto. In qualified veto, if president returned a bill for the reconsideration of the house has to pass the bill with a special majority. The second time, in case president return a bill, in that case, the house will have to pass it with a special majority. That's why it is called qualified veto. You have to qualify it. Then only, because second time it would be automatically passed. So if second time, if it is passed by a special majority, then it would be considered that it has got the assent of president. Okay. In India, there is no qualified veto. We do not have the concept of qualified veto in India. We have only suspensive veto, where the second time also it needs to be passed with simple majority only. Okay, and then there is no time limit which have been prescribed in India. In USA, there has been prescription of time limit also. So if in this, because of this reason also, the president can decide to do not act on the bill. This is called pocket veto. This was used by Gyani Jail Singh. The example of suspensive veto is APJ Abdul Kalam. This is President Gyani Jail Singh. He used pocket veto against the postal bill. So postal bill had the provision that government can, in the national interest, in the interest of security, public interest, etc., government can read any letter or postgraph, etc. So government can, if government feels that in this letter you are writing something which can be detrimental to national security, it can open the postcard or the envelope and it can read whatever you were sending. So this was something which was in the 1980s. So at that point of time we did not have email, etc. So the mode of communication was limited to telegraph and telephone and letters. So this was about letters. This was the bill that was sent. Later on what happens that the relationship between the president and the then Prime Minister Rajiv Gandhi was not good. So the president was very much afraid that probably the letters which are being sent, which might be sent to president, a lot many people do write letters which he might be sending, is also, can also be bugged, can also be read by the government authorities. So because of this fear, he did not sign on this bill. Okay. In fact, it was said that the relationship was so tense between president and prime minister that whenever a guest used to, I mean, the president used to believe that his house was bugged and the conversation that he used to do with his family and friends, etc., is being heard by the IB or RAW. So whenever he has to do anything important, conversation, etc., he used to take that person to the garden, to some other loneliness place out of his home, and there only he used to do those discussion. Okay. Any doubt with respect to any veto power? Next, see, similar veto power provision is with respect to governor also. In case of governor, the same provision is there except one additional provision, that is he can refer the matter to president. And in case the matter is referred to the president, then again president has the same option. He can give assent, he can withhold assent, he can send for reconsideration, and obviously don't do anything is there, because see, no time period has been prescribed for president as well. There is slight difference here. The constitution does not say that in case the president send it for reconsideration of the house, the next time if the house passes it with or without accepting the recommendation, the president has to give assent. So president can, you may write it down, president can send it for the reconsideration of the house any number of times. He is not bound by suspensive veto with respect to bills passed by a state legislature. But for governor, he cannot send it for n number of times. Governor has to give it his assent. So that's why if governor is not happy with any bill, usually what he does is he send it for reconsideration of president rather than himself rejecting the bill. Because if he sends it for president, the president can reject it any number of times. The second thing is that once governor sends a bill for the reconsideration of president and then the bill is passed again, it would again be presented to president only. It would not be presented to governor for his assent next time. So once governor refers a bill to the president, his role comes to an end. After that, the matter will lie with the president only. This is the common convention which is like our constitution is following everywhere. If you have surrendered your right is gone forever. For example, when two or more states request the parliament to make a law, then further that law would be amended or repealed only by the parliament. Those states have surrendered their right to make law on that topic. Okay, the similar thing is happening here. Once governor has surrendered his right to the president, then the rest of the matter would be dealt by president only. Then we have seen that there was this judgment that governor holds no veto power over bills, says Supreme Court. This is something that we have discussed already in one of the lectures. I will very briefly cover it again, that the Supreme Court has interpreted that the bills needs to be sent as soon as possible. In case the state assembly reinstates the bill with or without amendments, the governor has no choice or discretion, has to give his assent to it, rules Supreme Court. The Supreme Court says that the word as soon as possible means that if governor does not give assent, he has to send it for reconsideration. Supreme Court has read that if he withholds assent, in that case he has to mandatorily send it for reconsideration. So effectively what Supreme Court has done, Supreme Court has said that these two are one and the same. In case of governor, this is the ruling that has been given by the Supreme Court, that governor does not have any absolute veto. Now in the prelims there are chances of this question being asked. There, in case a question is that governor has absolute veto, your answer would be no. There is no absolute veto. Supreme Court has said that in case he withholds assent, he has to send it for reconsideration of the houses. And in case he send it for reconsideration, and that has to be done as soon as possible. So Supreme Court is saying that you do not have the pocket veto either. The constitution says that you have to send it as soon as possible. You cannot keep it with you indefinitely. But Supreme Court has not declared any timeline. So since Supreme Court has not declared any timeline, we can say yeah. So let's come back to this. The Supreme Court is saying that in case of governor, rejecting assent is same as sending for reconsideration, and governor does not have this choice to don't do anything, because the constitution uses the word phrase as soon as possible. As soon as possible means he has to do it ASAP. As soon as he decided that he withhold assent, he has to send it for reconsideration. So the only veto available is suspensive veto with governor. This is what the Supreme Court has ruled. That governor has only suspensive veto, and once this bill is presented again, if the legislative assembly passes it, then the governor has to give his assent. Obviously, this power to refer to the president, this power is still with the governor. Is it clear? No time frame has yet been provided. Like the people have again gone to the Supreme Court, not the people, rather the state of Kerala, Tamil Nadu. They have gone to the Supreme Court that please prescribe a time frame of 6 months. But as of now, the judgment is still pending. Supreme Court has yet not given its judgment on that matter. So, for the time being, there is no time frame. Supreme Court has only said that you have to do it as soon as possible. Once Supreme Court gives a judgment, you must leave some space over here. Once the judgment of Supreme Court is there, you should fulfill that space with the argument given by Supreme Court. Sir, after reconsideration, suspensive veto, can President use pocket veto when a bill has been sent back to President? See, as such, since like the phrase that has been used is the President has to give assent. So we would say that no, President should give assent immediately. Like we say na, that in case of Constitution Amendment Bill, the phrase that has been used is in case of Constitution Amendment Bill, the President must give assent. So we simply say, we interpret this must give assent as there is no veto power with the President. Okay, but since the concept of pocket veto has come because no time frame is prescribed. So that's why, in my personal opinion, again I have told you what you will write in the answers. But since there is no time frame that has been prescribed, and this is not only my personal opinion, a lot of writers also write the same thing, that pocket veto exists always because of the absence of time frame. But since in case of the governor, like people are going to the court and Supreme Court is asking the office of governor, why have you not given this why have you not given assent, why have you not decided anything? And it has been seen that as soon as Supreme Court asks the question, governor either give assent or send the bill for the consideration of president. So this pocket veto is not something which is explicitly written, and this is not something which is being said in the court by the governor that we are exercising pocket veto. The same we will come to know in case of president if the matter reaches to the court, because see, all these three different kind of vetoes have only been used by president once. There is only one example of use of pocket veto, that is the example of Gyani Jail Singh. Otherwise, president give assent in very routine manner. Whatever comes to him, he signs it. He does not make any objection. No, Yogesh, there is no timeline of 14 days or any such thing. In India, there is absence of timeline, and because of this absence of timeline, because of implicitly the concept of pocket veto has come to existence. Okay, so we would come to know only if someone exercises this. Like in case of governors were exercising it. So the matter went to the Supreme Court, and Supreme Court said that you do not have this pocket veto, but still Supreme Court has not given any timeline. In case of president, when the matter will come to the court, we will come to know. As of now, if the statement is there is no veto, you have to consider it right. When you have to write in mains, you have to write in the way wordings are there in the constitution that president has to give assent. Okay. After recommendation and passing of bill, again then, yes, exactly, like even in case of money bill also, the constitution only says that he cannot send it for reconsideration in case of money bill. So probably the constitution makers were not of the mind that someone will exercise pocket veto also. So later on he can change his mind, the president can change his mind. Okay, once it was also happened, there is one instance uh, that a bill was introduced in the parliament, which was supposed to be introduced with the prior consent of president, but it was not done so. So because of that reason, the president decided to exercise his absolute veto power, and he said that I withhold assent. Okay, so this was this was less of a matter of the content of the bill, more of a matter of procedure, the dignity of the office of president. Okay, so there has been exercise of absolute veto, like the same phrase withholding assent is used for president as well as governor. In case of governor, Supreme Court has interpreted withholding assent means that you say that you do not give assent, and so in that case you will have to give it for reconsideration. Okay, but in case of president, there has been exercise of absolute veto. There are examples of that, and the matter has not gone to the court. In case of president, Supreme Court has not given any interpretation. So I hope I will just summarize the whole issue with you. In case of president, withhold assent, the same terminology of withholding assent, the same terminology of sending it for the reconsideration of the houses are used for president as well as governor. In case of president, there are instances of absolute veto, suspensive veto, pocket veto. Similar terminology is there, but in case of governor also they were using all these three kind of vetoes. But now Supreme Court has said that in case they withhold asset, they have to send it for reconsideration, and that too they have to do it as soon as possible. So Supreme Court has simply said that you do not have absolute veto, you do not have pocket veto. The only kind of veto available is suspensive veto. In case of president, since there is no judgment, we would still go by our old convention, since the judgment was with respect to governor. Is it clear? Yes, yes, yes. Since there is no time limit provided, president can use pocket veto. Pocket veto can be used anytime. Next topic that we shall go is delegated legislation. Delegated legislation is different from ordinance. Delegated legislation is usually a necessary practice. Ordinance is also necessary, but it is ordinance is as such a law is passed, is made by president, whereas delegated legislation is made by executive under the guidance of legislature. So legislature itself sometimes says that, see, we have made the law, now you make the rules under it. For example, CAA, Citizenship Amendment Act, it was passed by the parliament, but the rules were made by the Home Ministry. Now you must have read in the newspaper that the rules under CAA were made, and after that, after the rules are made, rules are framed, then only the citizenship was given to the people. So these rules, which we are calling as CAA rules, or even like under GST also there is GST rules, these are example of delegated legislation. And the act itself says, sometimes it is, I mean, if you open any law made by parliament, invariably they would write some phrases like subject to the rules made by union government in this regard. Okay, as per the rules made by union government in this regard. Okay, so since implicitly or explicitly the legislation made by parliament says that the rules under this legislation shall be made by the executive, and these rules, obviously we have a hierarchy, then the rules are going to be inferior to the laws which are acts of parliament. And obviously these acts are inferior to constitution. So these rules cannot violate the laws, and these laws cannot violate the constitution. Obviously these rules cannot violate the constitution either. Okay, now write down the definition of delegated legislation. Refer to laws or regulations that are not directly passed by the legislature but are instead made by an individual or body under powers given to them by an act of parliament, or here write legislature, because the state government can also make delegated legislation. So the act of the parliament itself empowers some other person or authority or body to make rules or regulation or some other acts under that law. Those rules are called delegated legislation. Why the term delegated is because the legislature is delegating this legislation function to some other person. That's why the term delegated legislation, and these are obviously subordinate, as I have just showed you that these are subordinate to the legislation or act passed by the parliament. So that's why the name subordinate legislation is also used. Sometimes, obviously, the word secondary legislation is also used because they are secondary to the laws passed by parliament. The law passed by parliament is primary, these are secondary. So that's why these terms are used. They have the same meaning: secondary legislation, delegated legislation, subordinate legislation. Now the next question that must come to your mind is, why do we have the system of delegated legislation? Why is it that parliament cannot make all the laws? Why should parliament give this function to the executive? Because this is again violation of separation of power. The executive is not supposed to make rules or laws. When parliament is giving its function to the executive, it is in principle violating the separation of power. But it is required also. This is a necessary evil. Why? Because otherwise parliament would be overburdened. Parliament usually frames the broad outline of any law, what will happen. But the details and nitty-gritties of any law are mentioned in the rules itself. For example, let's take the example of CA only. The parliament said that, see, if the people are from these 6 religions, from these 3 countries, they can be given citizenship. Now, how are you going to ascertain if a person belongs to these 6 religions? What would be the document? Now, these are the nitty-gritty detail of how are you going to verify if these people have come from these 3 countries, and who is the person who is going to identify this. So, these are the technical things. These are the detailed things, and these are the things which would also require frequent modification. Suppose today you make a rule that say any religious functionary can give the certificate that he belongs to this particular religion. Tomorrow you may come to know that this is being grossly misused. People are coming up with fake certificate. Then you can say that the certificate by the religious machinery must be countersigned by a say district magistrate or a government official. So you may need to do frequent changes in these nitty-gritty small details which are required in implementation level. Okay, so because of these things, because of the need of flexibility, adaptability, okay, and detailed further detailing, we need to give these works to executive who is responsible for on ground, and there is also need of frequent changes. And obviously if parliament goes into those details while making a law, okay, it would not be very efficient either. So it also provides efficiency to the parliament, where it discusses about the broader aspect, and the small details are left to the government or those who are implementing, that you work out these small details. It will also bring about the reduce the workload of parliament. And one more thing is that the expertise, the technicalities that I told you, those expertise are also with usually with the executive body. For example, I will give you a very interesting example of tax laws. So, do you know the difference between biscuit and cookies? Yogesh or Manoj, please answer. What is the difference between cookies and biscuit, if any? I mean, you can say that there is no difference; both are the same. Size. Okay. So, as such, there is no difference. Biscuit is the terminology used in UK, British English, and the same item, like there is nothing called biscuit in US. In US, they use the word cookies. For similar thing, we use the word biscuit in British English. Okay, but traditionally, we have been using the word biscuit, and biscuit used to refer to those like Parle-G, marigold kind of things, which were biscuit, which were considered biscuit, and cookies were something which were fluffy, which were having more ingredients, and they were relatively. So traditionally, it was said that the biscuit is something which is eaten by those who are ill. When you fall sick, you eat biscuit, tea and biscuit, whereas those who are rich, they used to show off like having cookies, etc. This is something that by convention somehow in Indian society it happened to be developed, because initially we had biscuit by Britishers, those were in the nature of Parle-G and Marigold. So in India we borrowed from both something something, and we decided that this one class is biscuit, another class is cookies. But practically both are the, I mean technically both are the same thing. Government adopted this, and in the tax laws government said that they would be taxed differently. Cookies would be taxed at a slightly higher rate and biscuit would be taxed at a slightly lower rate. Okay, cookies, let's take an example. Cookies would be taxed at 12% and biscuit would be taxed at 5%. Now the companies which were making cookies, they came to know, and they probably understood this, that see, all are the same, what's in the name. So they simply started rebranding their cookies as biscuits. Suppose now you love hide and seek. So whether earlier you were calling it as cookies, that hide and seek is a cookie, as soon as hide and seek started attracting 12% tax, you renamed it as hide and seek biscuit. Okay, and this is how the companies claim that now that we are biscuit, we should be taxed at a lower rate, say 5%. These are the parachute coconut oil did not mention it as hair oil. Yes, yes. These are the smart things which are done mostly for the purpose of saving taxes. So these small maneuvering like expertise, what should be cookies, first of all, they would require very frequent adjustment depending upon how the other market variables, the people at ground are acting or reacting. Okay, and the second thing is that these are the understanding which is difficult to have at the national level, at the parliament level, at the lawmaking level. This is something which would be understood more by those people who are at the cutting edge level on the ground level. Okay, so that's why there is a necessity that we would have to have delegated legislation. Okay, there is no running away, but obviously we have to understand what are the issues with the daily impact or criticism of delegated legislation. So first of all, it is undemocratic. Why we are saying that it is undemocratic? Because lawmaking is being done by appointed people. So these rules are made by bureaucrats. So bureaucrats are not elected people. Lawmaking should be done by the elected people. So this is undemocratic. And also it is violation of separation of power. Again the same logic, law making should be done by legislature, not executive. And also, like, these legislature, these people are accountable to the people, where these bureaucrats, they are not accountable to the people. I mean, in governance you do a study that there is accountability as part of good governance, but practically they do not have to go to the election every 5 years. So as such, they should not be making law. So this is also, there is lack of accountability. Lack of accountability we are also saying because of the way in which laws are made. Usually whenever a law is made, there is a debate and discussion in the parliament. Everyone comes to know that which side had which argument, what were the argument raised, and what were the counter argument given, why we are having such and such law. In case of rules making, we do not know. For example, why this postmaster general has been given this authority to issue citizenship, we do not know it. Why not district magistrate? why this why these religious functionaries, how are they competent to issue this certificate? And who are going to be these religious functionaries who will issue this certificate that particular person belongs to this religion? Not. So there are a lot many questions about we do not have any answer to, because there is lack of transparency in rule making. You can give these examples, do keep one or two examples handy for giving answers. Okay, then obviously there is potential for abuse and misuse. Then there is complexity and over-regulation. This is the tendency of bureaucracy. Whenever bureaucracy get an opportunity to make laws, it has a tendency to over-regulate. I will give you my personal example. Like when I was in NABARD. So in NABARD, we sanction the projects for development. So one of the projects that we were sanctioning, I remember is uh, a project for promotion of rural tourism in Pangi. I was working in Himachal Pradesh. So in Himachal Pradesh, there is a Pangi. If you have not heard this name, you can Google it. This is one of the remotest region of our country. Okay, very close to, say, you can say Ladakh, that region, which remains in the time of winter for around 6 months. It remains cut off from the rest of the India. So for that Pangi region, we were sanctioning a developmental project for development of rural tourism. Okay, and when we sanction this project, so something which is very regular in nature, which is happening every month, so we have the standard procedure that these are the terms and conditions to be imposed. And since this was a project which was not regular in nature, this was being done for the first time, so we have to frame the terms and conditions on our own. So when I went to my senior, he said that think of any terms and condition that you can think of and put it there. Put it there that they will submit this document, that document, the document which they might not be having, audited account, tax certificate, blah, blue, everything. Literally. So this is like what I used to study in public administration, that this is how bureaucracy is always power hungry. I literally saw that over there. That there is a tendency to have as many terms and conditions. This is how our income tax rules are so complex. If you see, suppose you have only one simple income, you are earning a salary and you do not want to do any saving, etc., then you can file income tax very simply. But suppose you are having multiple sources of income, suppose you think of taking advantage of some exemptions, you might try to be smart, then only God helps you. There are so many rules and exemptions, and sometimes you will not find logic. Suppose you have there are, for medical treatment there are exemptions, so you will find the income tax return and tomorrow your friend will say, oh, you have not taken this exemptions for this medical treatment, for this preventive health care, for the insurance of your father, there is exemption. So there are so many provisions that are there, and that makes it very complex. You can give the example of IT rule, income tax rules. If you have spent money for, say, cancer treatment, you will be exempted. But if you have spent money for dengue treatment, you will not be exempted. But you can die by dengue also. It's not only that for cancer only you will die. If you have gone for dialysis, then you are exempted. But so for few diseases you are exempted. For few diseases which are equally life threatening, you are not exempted. Maybe because the finance minister was having that disease, that's why it got exempted from income tax. Such and such could be the reason. Maybe that the tax secretary, revenue secretary was having that disease. And this creates about ambiguity as well. There is confusion, there is ambiguity, which is often, which also leads to a lot of litigation. Suppose the income tax department or the tax department is not smart enough to differentiate between cookies and biscuit, it simply would have kept it like, say, you will have 5% tax or 12% tax. It would be simple, but since they are smart, they are making things more complex. It is leading to a lot of litigation. Okay. One more question that can be asked is what are the checks against delegated legislation? There are issues. It is undemocratic, violation of separation of power. There is issue of accountability. So that question can also be there, or you may also choose to write what are the checks against you. Will you tell me checks against delegated legislation? First, it is also subject to judicial review. So it cannot be violative of constitution. fundamental right, particular, and also the corresponding legislation. If it does any such thing, like it violates the legislation or the fundamental right, it can be declared null and void. And second is, there is a parliamentary committee on subordinate legislation. In prelims, there has been a question also on this, that which of the following parliamentary committees review the delegated legislation. So there is a parliamentary committee on subordinate legislation. This committee regularly reviews the rules made by executive. So whatever laws that are being made by parliament, under that laws, the rules that are framed are being routinely reviewed by this committee, whether they are complying with the law made by parliament or not. If they are violative, it is brought to the attention of the parliament, and then parliament may pass a law, may declare it, may pass a law to override those rules, etc. Okay. So these are the two broad, one by the judiciary, another by the parliament, ways to control the delegated legislation. If you have to write the way forward, what would you write? First thing is, the problem is, sir, please tell the example which you told in impact. I told one example is income tax rules, which are very complex. Another example that I say is rest all is like explanation only. Like in case of transparency, you can write that Citizenship Amendment Act CAA rules were framed or were framed without consultation, like the general public was not aware what are these rules going to be. Usually, like consultation means first draft is released, on that people are asked for their opinion. When they give opinion, like various stakeholders meeting happens, and based on that a consensus is built that this is going to be the rules. Okay, so because of this reason, which certificate are you asking about? I'm not getting the point. Next is like mandatory public consultation. This is one suggestion that we can do. Example about certificate. I am not able to recall. If like other Yogesh, if Manoj, you can help him. I'm simply not able to locate what is his doubt about which certificate he is asking. Okay, let's come to this point. Mandatory public consultation. This is one advice. One advice that you can give is that the consultation, there should be mandatory public consultation before making rules. And there should be a process which should necessarily involve releasing of draft delegated legislation before the final. So first you must release the draft, you must ask for the opinion of the civil society and all the stakeholders, and then only you should come up with the final rules. This should be the process. And then while making any law by the parliament, there should be clear delegation of authority. The parliament itself should clarify that what is going to be the limits of delegated legislation. A lot many times this is absent. The parliament does not clearly mentions in the laws that who is going to make this delegated legislation, who is going to and what is going to be the limit of delegated legislation. Then there should be a regular review and updation of these delegated legislations. And in case it is not regularly reviewed, there should also be a sunset clause. Sunset clause means that at a particular time it will come to an end. So if it is not updated or renewed, it's like when you take a subscription of say any gym, etc. So if you do not make the payment again after 1 year, your subscription will come to an end. So that is called sunset clause. The law, if the law is not passed again, if it is not reviewed and updated, then at a particular time it should come to an end. This will avoid the complexity and unnecessary legislation. There are a lot many laws which are archaic in nature, which are too old, which are irrelevant nowadays, outdated, but they are still existing in a statute book. They need to be reviewed and phased away. Next is there should be training and capacity building. It is not necessary that if you are a good say functionary, a good bureaucrat, you are a good lawmaker as well. Lawmaking is a specialized function, and since these rules can be challenged in a court of law, so probably the lawmakers and bureaucrats need to be trained in lawmaking as well. What are the words to be used? What are the words that can have various meaning, various interpretation? So to avoid litigation, they should also be trained for lawmaking purposes. Okay? Do you have any doubt? Next item in our today's agenda is ordinance. How many of you have seen this video? Which movie? Can you recall it? The statement here says that एक छोटा सा ordinance pass करना पड़ेगा बस. There is a need to just pass a small ordinance. To do what? Yes, your guess has identified it right. This is a scene from the movie Nayak. In that Nayak movie, you may recall it, that Anil Kapoor was taking the interview and all of a sudden he was the chief minister. He offered him to be a chief minister for 1 day. And he simply said, or this is the statement which was there in this movie for 2-3 times. It is possible. You have to just pass the ordinance. You know, after studying polity, I came to know that to implement that thing, even an ordinance was not required. Any person can be made a chief minister of a state if the MLAs agree. If more than 50% of the MLAs agree to make any person a chief minister, suppose today by God's grace all the MLAs of any state decides to make Madhusudan Sarma as chief minister of that state, I can be made chief minister even though I am not an MLA. Okay, the only criteria which is there should be that I should be the citizen of India, I should be a voter, registered voter. So all those qualification criteria I should meet. I should not be either disqualified. I should meet the qualification criteria. Then I can be the chief minister. But okay, let's take this matter. Why? What is this ordinance, and why was he party chahiye? No, not even party. So suppose somehow I have something that I can tell Chandrababu Naidu that you should resign and you should make me chief minister. Somehow I convince him. Obviously, Chandrababu Naidu will convince his MLAs later on. So this is how it happened here. Like this person who was he was the leader of his party. This person was convinced. So he made Anil Kapoor the chief minister. So that is a possibility. Now, what can happen next? Like, and why was he referring it as ordinance? Like he could have said that I will have to make a law. He said ordinance because ordinance is easy. It is only the chief minister or the prime minister, and in constitutional term it is the governor or president which is involved in passing an ordinance. You need not have a session of the parliament. You need not have to debate, discuss. You need not have to refer the matter to the parliamentary committee or any such thing. This is easy, as easy like this. Okay, okay, that party you are talking about, I missed the context. Definitely you will get the party, huge party to all my students. As of now, that's a dream and you can get the party in your dream as well. And let's talk about some constitutional aspect. The first thing is that Article 123 mentions about ordinance making power of president. The governor also have the similar ordinance and he gets the power from Article 213. Okay. And the condition is that when either house of the parliament is not in session. So there are two houses of the parliament. If either of the two, either Lok Sabha or Rajya Sabha, is not in session, it is not required that the house is dissolved. It simply should be prorogued. Not in session means the house should be prorogued. There is another term, adjournment. Adjournment is temporarily ending the sitting of the house. Okay, for a particular period of time, maybe it is adjourned till tomorrow. And so in that case, in case a session is in case house is adjourned, it still remains in session. So the house should not be in session means house should be prorogued, and proroguing is done by the president, whereas adjournment is done by the presiding officer. So the condition in ordinance is that parliament should be prorogued either house, and it is done by president. After that, the condition says that when circumstances necessitate immediate legislation. So it is a legislation. It is a legislation made by the president or governor, which is called ordinance. And if circumstances is that the parliament is not in session and there is a need for legislation, it can be made by executive itself. And then there is a condition also that okay, you can make a law immediately, the president can make a law, but after that president has to, after that what has to done, whenever the house comes to session, obviously the house will come to session after some time. I mean, there cannot be a gap of more than 6 months between two sittings of the house. So after the house comes to the session, within 6 months, 6 weeks, within 6 weeks of their reassembly, the ordinance has to be passed by both houses. So ordinance has to be converted into a law within 6 weeks. So it means it is simply saying that executive can make a law in emergency, but actually lawmaking is the function of legislature. So you must convert it into a proper law as soon as legislature is available, and a time period has also been given by constitution, that is of 6 week time period. Okay, but as we have seen in this movie that this provision is prone to misuse, and so has happened in real life as well. There has been frequent misuse of this provision. So what are the issues with ordinance? If the ordinance power is there, one is obviously that it will be misused, but there are certain in principle problem as well. First is that you are bypassing the legislature. This is again violation of separation of power, because today's topic is separation of power. So obviously everything that we study, this is one problem that is going to be there, and you have to write these things even if it seems very basic to you, but you have to write these points. Next is, it is very often used for political expediency rather than genuine emergency. for various political reasons, etc., it is used. Can you give me some example of ordinances? For example, Farms Bill. Farms Bill, they were passed as an ordinance. Even Land Acquisition Ordinance. So there was no emergency that has all of a sudden emerged, because of which you have to pass the Land Acquisition Ordinance. Land acquisition was happening in this country for last 7 decades. It would not have, the heaven and earth would not have moved if it would have stopped for again another 6 months. So time and again, there is no genuine emergency, still this provision is used. In fact, the another problem, see, the problems are similar as that of delegated legislation. There is lack of transparency, there is no debate, discussion, etc. The same problem you can write here also. Only thing is that here we will have to give the examples of some ordinance. There you have to give the example of some delegated legislation. In principle, the problem is here the same, that it is bypassing legislature, there is violation of separation of power. But the conclusion would be different. The conclusion in delegated legislation would be that this is necessary evil. You have to have delegated legislation. There is some benefit as well. We have seen that why it is required also. There is technical expertise, there is detailed, there is unburdening of legislature. Whereas there is no such benefit here. Ordinance should be avoided to the extent possible. Here the conclusion would be that we should not use ordinance. There the way we have written the way forward also, how we can control it. Okay, so that's how the two terms are different. Regions and issues are same. One another issue is issue of re-promulgation of ordinance. So few people become very smart. They said that okay, if we bring this matter to the legislature, probably there is going to be a lot of din and noise. So why don't we do it? We issue an ordinance. We get time till the legislature comes into session. After that, we get the 6 weeks time. What if legislature is prorogued before 6 weeks? Suppose the session of legislature is only for the 5 weeks. In that case, what will happen? Before 6 weeks, we can, once the legislature is prorogued, then again the ordinance can be issued. Since the legislature is not in the session, again it will continue till the next session. So if we simply have the session of legislature for less than 6 weeks, we can continue issuing ordinance without the need of passing a law. And the same was done in Bihar time and again. In fact, for Bihar, it was a data that came that 256 ordinances were issued. 256 ordinances were issued between 1967 and 1981. So in this 14-year time frame, 256 ordinances, on an average 14 ordinances every year. And this is the same number which is being issued these days as well. Okay. In 2019 also, the government issued 16 ordinances. In 2020, the government issued 17 ordinances. Sorry, it is 15 and 16. This is about central government, not Bihar government. This is about central government. So you will give this data to say that still ordinances are very frequently being used, and some of the important, all the important legislation like even Aadhaar bill was issued as an ordinance. Land acquisition ordinance we have seen, farm bills were issued as an ordinance. Let's come back to our matter, and in fact in this case between 1967 to 1981 it was also noticed that some of the ordinances they remain in force between 10 to 14 years. So they remain in force between 10 and 14 years without being converted into a law. And they related to issues of land reforms. So land reforms was obviously a contentious issue at that point of time. So what government was taking a simple route, issue an ordinance, do not pass it through the legislature and do the land reform whatever you wanted to do. This is an issue of repromulgation of ordinance. Obviously, the Supreme Court would not have sit quiet. So Supreme Court said that in the various cases, Supreme Court has declared this practice as unconstitutional. So the first thing is that in R.C. Cooper case in 1970, Supreme Court said that President's decision to promulgate ordinance is subject to judicial review. The Supreme Court said that okay, we will not go into the detail what kind of advice was tendered to the President, because that is something which is beyond judicial review. But the matter on which President's satisfaction was achieved, we can definitely examine that matter. Okay, where there was, and in case ordinance has been issued for any malified ground, okay, that is it was issued to bypass the debate and discussion, in that case it can be declared null and void. And in case of DC Vadhava case, DC Vadhava was a professor in Patna. It is not important, just to give you the reference. He, uh, in this case, the Supreme Court says that this is an exceptional power and it is not a substitute for law-making power of legislature. So you cannot bypass or replace the legislature by ordinance. So repromulgation is a culrever exercise of power and it is unconstitutional. So it was simply Supreme Court declared that repromulgation of ordinance is simply taking away the power of legislature by executive, and this is unconstitutional. Now this is the difference between letter and spirit. In letter, as per the constitution, the executive was not doing anything unconstitutional. But Supreme Court interpreted the due process of law. The spirit of constitution was not that you can repromulgate the ordinance, you need not pass it as a law. The spirit of constitution was that it's an emergency measure. Only in exceptional circumstances you have to use it. So Supreme Court says that repromulgation is an unconstitutional. The same opinion was again stressed in Krishna Kumar case in 2017, where Supreme Court says that repromulgation is a fraud on constitution. If you are repromulgating a same ordinance again and again without passing it through legislature, it's a fraud on the constitution and it is subversion of democratic legislative process. It is anti-democratic. The democratic process is subverted. This is not allowed. This is unconstitutional. So these cases you have to quote, especially this DC Vadhava case. Without these cases, your answer is incomplete. Any question on ordinance, the examiner will definitely be looking for these cases. Okay. One question is again here also a question is asked that what are the protections protection against ordinance or protection against misuse of the ordinance power. So the first thing is here also ordinance is subject to judicial review. So ordinance cannot be unconstitutional, cannot violate fundamental rights. etc. Also all those protections which are applicable on say normal law, the same is applicable on ordinance also. Like parliament cannot issue an ordinance on a state list. It can issue ordinance only on union list and a concurrent list. So all those limitations on parliament which are there with respect to normal laws are there with respect to ordinance also. Then it can also be, as per this R.C. Cooper case, even the president decision to promulgate ordinance is subject to judicial review. So that R.C. Cooper case you will write. Then you will say that within 6 weeks it has to be passed by both houses of the parliament within 6 weeks of reassembly. Then when it is introduced in the parliament, a explanation for contingency is statement of explanation is given by government. A statement of explanation for the contingency is given by government. That what was the reason, what was the contingency that has arrived for which an ordinance was necessitated. So this is another checks. And then you can say that in DC Wadhwa case, the Supreme Court has said that re-promulgation of ordinance is unconstitutional. And you can also add DC Wadhwa and Krishna Kumar case. In Krishna Kumar, simply Supreme Court reassessed its earlier judgment that this is a fraud on constitution. I love this word fraud. Okay. And then after that you can give some way forward as well. That the suggestion that people are saying that the time frame needs to be reduced to 15 days. When you are giving 6 weeks of time frame, effectively it is allowing the process of repromulgation or subversion. If the time frame is reduced, the ordinance rule or ordinance raj is not possible. Okay. And since it is a matter of contingency, some emergency has come, obviously parliament would also prioritize this matter. So when a session of the parliament begins, it would first take up those matters on which ordinances have been issued. So in this case, only what to say, emergency matters would be taken. Today what is happening, that all matters are being addressed through uh, ordinance route. Okay, and then through a constitution amendment we should explicitly prohibit the repromulgation of ordinance. As of now it is through a Supreme Court judgment, and Supreme Court judgment often sometimes the government have a tendency to take a chance. Only if you go to the Supreme Court, then in 2, 3, 4 years of time Supreme Court will give a judgment. By that time people will do their duty. The government will able to succeed in its agenda. Okay, and there is something which is followed in France. The France also they have given executive. I mean, in France they have this provision that in case ordinance is defeated in the legislature after it is introduced, there they call it National Assembly. So in case it is defeated, it should mean that there is loss of confidence in Council of Ministers. It acts as a deterrent against frequent misuse of ordinance provision. They cannot take a chance until unless it is very necessary. The government will not take a chance that, because if the ordinance is not passed, it is defeated in the parliament, then it would be considered loss of confidence. Obviously, the government will have to pass a confidence motion once there is a loss of confidence. Okay, and then in the end you will write that it should be, this is an emergency power, it should be used sparingly. It should not be used very frequently. This is what you will write in the end, and you will conclude your answer. This is an emergency provision. If you use the emergency power for a day-to-day business, it means you are somehow misusing the provision. Okay, so that's all that we shall cover in today's class. We shall again meet. We shall start about the judiciary. We shall discuss about the collegium system, the need for the independence of the judiciary, and other matters related to judiciary and alternate dispute resolution as well. Okay, so in case you have any doubt, you can mention it in the comment section. I will be happy to answer it tomorrow. See you again tomorrow at 2 p.m. Take care. Have a nice day.